Well, obviously, we know that Hope is in charge as she rearranged the seating pattern even of our presenters today. So that's great. So Hope Fredrickson, obviously a solo general practitioner up in the Sinclairville area. During her 30-year career, she's had a concentration in residential real estate along with estate planning and estate administration. She obtained her undergraduate degree from Houghton College and her JD from Dickinson School of Law in Carlisle, Pennsylvania. A member of the Jamestown Bar Association and the Real Estate Committee and Continuing Legal Education Committee, and she served on those for many years. Next to her is Neil Robinson, a graduate of Syracuse University, and he received his JD from Cleveland Marshall College of Law. Lifelong resident here in the area, as we all know. His practice concentrates on representation of small business and the formation of small business entities, along with real estate law through the representation of the buyers and sellers and lenders. He's a licensed New York State title insurance agent and has been appointed as examining counsel for the First American Title Insurance Company and Fidelity National Title Insurance Company. Serves on a number of boards here in the community, member of the Jamestown Bar Association, also serves on the Real Estate Committee, and a member of the New York State Bar Association. Next to him, on my far left, Randy Cannon, Vice President and Assistant General Manager and Title Officer of the Chautauqua Abstract Company, licensed by New York State Department of Financial Services to act as a title insurance agent in the examination of titles and the marking up of title commitments. Bachelor's Arts degree in history from Bob Jones University in Greenville, South Carolina. So we'll turn this now over to Hope to lead the discussion. Thank you.
So much. Well, I want to tell you a little bit about how this came about. The Real Estate Committee meets frequently. It's an active committee of the Jamestown Bar Association. And we were talking about some of the younger attorneys that have joined us in the real estate practice. And we thought that perhaps some of the younger attorneys and maybe even some of the legal assistants in the offices would appreciate just having a primer on real estate closings. As I look out in the audience, I think many of you are what I would say probably more seasoned real estate attorneys and assistants. So I'm afraid probably you may do some yawning through this. I tried to think how we could present it in the Michael Jackson fashion, do a little song and dance, but I'm afraid we're going to have to stick to the lecture. So. But I want to acknowledge the wonderful contribution that the co-chairs of the Real Estate Committee have made over the years, and that would be Bob Van Every and Greg Yaw. Neither of them are able to be with us today, but they have really taken their committee responsibilities seriously. I think they've contributed greatly to the forms that we use and to the practice and making sure that we do it in a good, pure way here. And I, when I've dealt with attorneys from other counties, Erie County and other counties, it really makes me appreciate the quality of our transactions here. I also wanted to acknowledge John Norton Dahl. He also was not able to be with us today, but he contributed a good deal of time to help put together the materials that you have in your course book. And we're going to cover those materials as we go along here. I want to encourage you to ask questions as we go along. We really would like to have your questions, so don't hesitate to put your hand up and interrupt us as we go. We're going to start this morning by dealing with the contract for sale of real property, and even the contract is always a work in progress. At our latest Real Estate Committee meetings, we have been discussing some updates to the contract, and we welcome your input on that as well. I'm going to have Neil, if he would, talk to us about the aspects of the contract for sale.
Thank you, Hope. Well, we aren't going to diagram the sentences in the contract, but just look at a few things. I want to echo what Hope said. I look out and I see people who certainly know as much or more than I, and they tend to remind me of that on a weekly basis when we talk, but you're up there and I'm here, so I'll start. The contract, what we've done is, brokers and real estate agents are not supposed to draft contracts. That's considered the practice of law in New York State. So in order to keep some uniformity, and so that we don't have to draft every contract from scratch, the Jamestown Bar Association has adopted the uniform contract, which the realtors are allowed to fill in the blanks. And we've tried to keep that contract so that we address most of the issues that come up in a real estate transaction, so they can be, the blanks can be filled in, and we don't have, crazy things. The contract's set up so when you get the contract in the office, theoretically, you can contact your client because their address and phone number are supposed to be there. More often than not, they aren't, but they're supposed to be. And you got the tax parcel ID, things you can get at it quickly. One of the things, when you're looking at the contract, make sure you catch the seller's concession. Sometimes easy to overlook that. If that's filled in with a number, highlight it, remember it's there. And the other thing in paragraph 5, which is something that very seldom comes up, but it's in there, and it's not a time is of the essence thing. It's just there that the purchaser has a certain time period in which to get their mortgage commitment. And if they don't get their mortgage commitment, either party can cancel the contract. That's something I think that we often ignore. We don't pay much attention. Some attorneys that I deal with pay more attention than others. But you don't have to put the other side on notice. You can just cancel the contract. So that's something you need to be careful of, and if your client hasn't received their commitment by a certain date, check with them and see how that's going on, and see what's going on. Because it'd be kind of an unpleasant surprise to have to get a letter from the seller's attorney saying, well, your client, the purchaser, didn't get their commitment by yesterday, so the contract's over, and you go, what? And so that's something that we do need to be conscious of. I think John Cordes pointed that out to me a couple of years ago, and I received the letter and I said, what? Eventually his client relented, but it keeps you on your toes. The other thing on paragraph 11, the long paragraph, the way that contract is written, if you, as the examining attorney representing the buyer, find that the title is not marketable, that doesn't mean, the way this contract is written, that doesn't mean that your client the buyer can back out if they want to, because the seller has an absolute right to attempt to obtain title insurance. So the seller always has that right. And the other thing about there, is we put in the contract that the mere fact that there's objections, liens, mortgages, etc., which are going to be discharged at closing, does not under this contract make the title unmarketable. Surveys, it always surprises me. A seller will sell a house for $300,000 or $400,000, doesn't want to spend $600 for a survey, so they put existing survey, and then the affidavit of no change. I mean, frankly, I think we all know that the affidavit of no change is really a worthless document. If something's happened to change that survey, the affidavit of no change doesn't do anything for you as the buyer, really. I mean, you aren't going to be, suing the seller after closing over an issue, I wouldn't think. It's always best, I think, and I don't know what everybody else thinks, but it's always best to try and get new surveys, and candidly, if I'm representing the seller, I always ask if the buyer's attorney will accept the existing survey, and Sam Price told me Friday no. So, and being the uncle and father of a couple of surveyors, we like to encourage surveys. It relieves the pressure of dad paying the student loan. But I mean, I think that's something that, you know, and sometimes the way that's filled out, we don't know what it says. But I think it is, if we can try and insist on new surveys, we'll all be better off. Yes.
Before you leave paragraph 11, I did want to mention that the aspect there where the buyer does agree to accept title insurance if the seller can provide it in the event that the title is unmarketable, that was a fairly new provision within the last couple of years. We didn't have that provision in our contracts prior to one of our more recent revisions. So I always explain that to my client, that basically if you sign this contract, you are agreeing that if we run into a title issue that can be insured over, you are agreeing to accept title insurance.
Yeah, I think that's important. We did add that a couple years ago. The other thing, the seller's client, seller as a client always asked, well, I'm selling this property as is. Where does it say that? And I said, well, I know it says it in here somewhere. Well, just remember this when they ask you the question, so it sounds like you know what you're doing. It's paragraph 14, all right? That's the as-is paragraph, and it does not apply to the well and septic. That's a whole separate issue. So the conditions of the premises doesn't mean the well and septic. So that's something you can say. We always look at it. Just check paragraph 14. Paragraph 17, the one where we write threatening letters. You know, people have to do this sometimes, and just remember it's 7 business days, not 7 calendar days, so there is always a you know, little time there for the buyer or the seller to comply. I don't know. I've never personally been involved in a situation where there's been litigation out of that particular paragraph. I don't know if anybody out there has. Good. In the standard rider, you know, we added this to try and put some more information, resolve some issues. You got the home sale and closing contingency. Remember that section is both the contract, property under contract and closed by a certain date. It's supposed to be both. And the home inspection contingency, I think the important part of that is it was added that if the purchaser is unsatisfied with the home inspection and wants to get out of the contract, the purchaser does not have to disclose to the seller what they're unsatisfied about. You know, previously, those of us who've been around for a while, remember the purchaser would say, well, it's got a drain problem, or it's got this problem, and then the seller would say, no, it doesn't, and you go back and forth with all that BS. Well, this makes it a little cleaner. It says, look, the purchaser just has to say, I'm unsatisfied, I want out. So it's essentially what this contract does is give the purchaser a right of rescission. You know, I mean, we've had clients ask us, well, I've signed the contract, don't I have 3 days to get out of it? And we say, no, this is not door-to-door sales. But this does give them a right of rescission. If they enter in the contract and get cold feet, they can always do the home inspection, and no matter what it says, they have a right to get out. I don't know if anyone's had any litigation on that issue. No. We don't litigate much on real estate, thank goodness, but as much as we threaten.
Neil,
Yes.
Yes. Go ahead.
Well, the seller is supposed to fill out the property condition disclosure statement, which on that statement, and provide it to the purchaser before the purchaser signs the contract. And it should have been addressed in the property condition disclosure statement.
Maria, I think you're talking about the home inspector who felt that they had a duty to disclose?
Yep. Oh, they were disclosing to the homeowner. I'm sorry. Okay. Yep. Oh, sure.
because it was.
Yeah, the safeties are, right.
And so they said regardless that he did not purchase the home, they had a duty to warn.
Yes, well, I think probably the home inspectors, I don't know much about what their training is, but they're probably told if they see in their training, an extremely dangerous situation to whoever occupying the house, so they probably have some sort of duty to disclose it, yes.
But I think typically the home inspection report would be confidential between the person who contracted for the report and the
But I
inspector.
think in New York State, as you know, it's got a goal of protecting ourselves from ourselves. And so they probably, I would assume, maybe it's making assumptions, but I assume it's probably they're obligated as licensed home inspectors to reveal life-threatening or dangerous situations. It's probably a good idea.
Neil, I was also going to mention that a few years ago, at the request of the realtors, the real estate committee did promulgate a form where if the buyer found the home inspection to be unsatisfactory, but there were repairs that the seller was willing to make, we have this addendum to the contract form that we have put out, and it indicates that the purchaser has found the home inspection to be unsatisfactory, but is still willing to complete the transaction if the seller is willing to complete, and then you list the agreed repairs prior to closing. So that, we didn't put that in the materials, but we do have that addendum, and I think it's on the Bar Association website.
So what,
If not, you can call me.
it's kind of a counteroffer
Yes.
that the seller
yes.
has to accept, yeah. And, obviously, we have dates and things in these contracts, but you have somebody who really wants to sell and somebody really wants to buy. The parties tend to work those issues out. One more thing before I go on to the water sewer rider. We see the contracts with initials at the bottom of the page. The official Jamestown Bar Association contract does not have the area for initials. That was an unauthorized addition by the realtors. We prefer you not use the ones with initials. It tends to confuse things because somebody will initial one page and not the other, or both parties won't initial the same page. Then the lender gets it and the lender goes nuts, and you're running around. The other thing on the standard rider, as you know, you got the home sale escape clause there. Pretty well self-explanatory. On page 2 of the standard rider, the rental property, information on the rentals, that's never filled out, but it's there. And then the important part of that standard rider is section G, the additional changes. That's where you can add stuff, certain contingencies, things like that. That's the place to put them. It gives you some space. Years ago, we were stuffing those additional contingencies all over the agreement or doing addendums, but you can put it right there. It's not in your materials. It was an omission, but we have the water and sewer rider. If you're dealing with rural property, this is the bugaboo for all of us, all right? There should be a additional fee for dealing with escrows, but tough to get that through, but they are a headache. The contract, the way it was written, has the escrow agreement right in it. And, section 3. It's never filled out because I believe realtors don't feel comfortable filling it out. And by the time we get the contract, it's been signed and everything, so we end up doing separate escrow agreements. It would be nice in a perfect world if it was filled out for us and we wouldn't have to monkey with it. Or sometimes we do these things and a septic escrow agreement is omitted completely, and then the buyer doesn't move in for 4 months because they're rehabbing the house, and the sellers wants their money back, and then all of a sudden it's January and we aren't going to have that septic inspected till April or May. I don't know what the answer is in those situations. I kind of think that when you close a house, if there is no well and septic escrow agreement, that there is an implied good faith effort for the seller to move in and have these tests undertaken. I don't know, what's everybody else think about that? The buyer, yeah, the buyer.
Yeah, it can be a problem.
Yeah.
because,
It's a big
you know, you
problem.
have
It's a big
people
problem.
going to rehab and not
Yeah.
in there, and the sellers rightly, they have certain expectations around. I don't know if there should be something built in that somebody consider a real estate committee, something, some obligation or at least a disclosure, that there's no intention of moving in for 5, 8 months while they do a rehab of the house. It's
I
not
almost,
fair to the seller.
no, it isn't. Yes, Paul?
How do you arrive at an agreement as part of the amount of the
Well, what we've been doing is the standard cost, which is $6,000, $7,000, $8,000. Now it's 85. So we, generally, it's under the, in the contract, the parties can agree right at the time of the contract. Of course, many of them would have no idea. I think in the Jamestown Bar Association, we've been generally using the figure of $8,500. However, where you have to be careful now, is kicked in the lakefront septic tests, because if a property is lakefront and the health department says it needs a new septic system, whether it be Chautauqua Lake or Finley Lake or Cassadaga Lake, you could be talking about an engineered septic system, so you could be looking at between $20,000 and $30,000, and the buyer's attorney is holding $8,500, and the seller says, catch me if you can. So, and the health department's saying that septic has to be replaced. So I think what we need to be careful of as lawyers is when we do know the property is on the lakefront and we're representing particularly the buyer, that we try to get some idea before closing of what we're looking at with respect to that septic system, because it can be a terrible expense to replace a lakefront septic system.
The other issue too is that sometimes the banks have their own requirements. If you're dealing with a lender for the purchaser, whether or not there's a statement in the water and sewer rider that it's going to be $8,500 escrow, the bank may require that estimates be obtained. Sometimes they say it's got to be 1.5 times the highest estimate. So it does make it very difficult. I think this is one of the most difficult parts of residential real estate, because I'm in central Chautauqua County, so it's pretty frequent that the transactions that I deal with will have a septic issue. And water too, the water wells are problems as well. I don't think I've had one transaction this entire year where the water passed the first time, so that's another issue as well. But sometimes you just have to go along with whatever that particular transaction circumstances might be, whether there's a bank involved.
It's, they're major headaches, no question about it. I tell you personally, there's no greater feeling than having your septic pass when you knew for sure it was going to fail. It's found money. And so that's pretty much the contract. It's you're all familiar with it. It's how we start the transaction, and it's the basis of it. And I think why we're here today, because hopefully we all enjoy dealing real estate, doing real estate closings. It's as an attorney, I always try and remember as many of them as you have when they get backed up, and due to my inefficiency and the headaches, partially due to my inefficiency, it's a big deal for the clients. It's a real big deal, and try and remember that. And I think we probably would all agree that it really is kind of satisfying to represent a young couple when they buy their first house, and they come to closing. Sometimes they bring their parents, sometimes they bring their toddlers, sometimes they bring their infants, but it's a big deal, and it is enjoyable. So, any questions on the contract? Yes, Jan.
Can you touch on the seller's concession again? If there is, they give you like a $3,000 discount, but you have to increase the price by $3,000 just to get the discount. You have to disclose it on the form as
It's disclosed on the contract, okay? There's nothing illegal or immoral, the way I understand it, about seller's concessions, as long as the lender understands that's what it is, okay? And the lenders wanted us to put that language in the contract. The concessions characterized as a contribution to closing costs and prepaids of the purchaser to satisfy the requirements of purchaser's lender. So, I mean, obviously, what you're doing is, you're increasing the amount of money the purchaser can borrow on the house, is a net effect of it. Because if you add $3,000 to a $50,000 house, now it's a $53,000 house, it has to appraise at that. And if the percentage of the loan, whether it's at 80% or 98%, you push the amount of the loan up, so it gives the seller more money in their pocket, because instead of 53, they're actually paying 50. So it's perfectly, as long as it's disclosed and everyone's aware of what it is.
And the TP form would be for the 50 or for the 53?
It's my understanding that TP is 53 because New York State wants to charge every cent it can for taxes because it's New York State. Now, the confusion that I had, I always thought on the RP, you listed the full pumped-up price and then put a note saying it's a seller's concession. I made the mistake of reading the instructions in preparation for this. And it says, no, you reduce the full sales price, where you put that in, by the amount of the concession. So I don't know what's correct. Maybe,
TP has one number on the RP.
yeah, but the RP, I always put the little asterisk and say $3,000 seller's concession or something like that. So I don't know which is how you're supposed to do it.
I don't think the county clerk will accept the recording if you've got two different figures on your RP and your TP. I think they do have to correspond.
So then you'd put the note.
Yeah.
I got a note here. We're getting ahead of ourselves, but it'll save me from talking at that point. This is the RP 5217. When I started practicing law, the buyer signed a deed. It cost $15 to record, and the seller would sign a note and mortgage, or sometimes the seller had to sign two papers at closing, a note and a mortgage, okay? So this reiterates my position in life that all change is bad. But at any rate, it says, do not include seller's concessions in the full sale price. The buyer and seller have agreed on a price of $100,000 for the purchase of the property. As part of the agreement, the seller will pay $4,000 of the buyer's closing costs. Therefore, the actual full sale price paid by the buyer or received by the seller is $96,000, $100,000 minus $4,000. So I don't know what to do. Okay. Maybe continue making put the full pumped up price on the RP and just put the note that I've been doing. They seem to accept that. I don't know what the assessor does with that, to be honest with you. Okay, I've taken up too much time.
I just wanted to mention that I'm sure you folks know that the Northern Chautauqua County Bar Association does have its own contract form that it has promulgated for their closings. It does differ from ours fairly substantially. The water and or the sewer and the water well provisions are right in the contract form. They have an attachment for the different types of mortgage financing, if it's going to be seller financed or if the buyer's going to apply to a lender. So we didn't put it in your materials, but if anybody's interested in having a copy of it, I'd be happy to send it to you. And I apologize if there are any Northern Chautauqua County Bar folks here. I don't see any, so, okay. All right, well then, we are now going to go on. Oh, the agricultural district notice, we'll just point out that there are some notices. That particular notice, if it's a rural property that has been designated by the municipality as an agricultural district, the seller does have a requirement of disclosing to the buyer that agricultural activities take place, which of course would mean potentially odors, noise, tractors on, farm equipment on the road, and the disclosure of that is a requirement. And again, we have these forms. I think they're available on the Jamestown Bar Association website. Randy is going to now address the standards for title examination. We have both the Jamestown Bar Association standards, which are some variations, and then the New York State Bar Association standards.
Well, good morning. I'd like to thank the Jackson Center for the opportunity to be here. I'd like to thank them also for having the nice weather so we could drive down here, although maybe we'd rather be outside than in here today. But in looking at the standards for examination of real estate, most of you probably are familiar with what you have in your materials, and I certainly won't read to you every single line. We'd be here pretty much past bedtime if we were to do a thorough examination of the Bar Association standards. The way I'm looking at this today is from the viewpoint of a title company. Now, I spent the first 10 years or so as a title searcher up at the courthouse doing real estate records, and of course, the reason for doing what I did is basically because I told you so. When I got down to title insurance, it became more clear as to why we do what we do as far as an abstract company and also as a title insurance company. And if you've got your page open to Section 3, the Jamestown Bar Association, you'll note the very first things. For title examinations, it's governed or adopted by the New York State Bar Association on January 3rd, 1976, which if you flip a few pages, you will see what those exactly are. And so you'll see a lot of similarities there, but you'll also see a few wrinkles that has been mentioned before. Now, what's helpful to note on these topics is that they all kind of dovetail together. You know, the contract is based on what is acceptable for examination, what is acceptable for survey standards, and so on and so forth. And because we write title for pretty much all of upstate New York and some parts of central New York, it's to be noted that obviously the contracts vary greatly from one county to another, and so you have to kind of defer to, as a title company, to whatever contract is being used in this particular real estate transaction. And I'll point out a few of them as we go along. I won't spend too much time on number 2, the abstracts of title, but you'll see there that it's supposed to be by an approved abstract company, incorporated abstract company. Item 3 mentions a 10-year tax search, and I will comment when we get to the title searching aspect. And of course, item 4 is basically where does that search need to start? And of course, as you see there, it is at least 50 years. That goes back to a warranty deed, administrator's deed, trustee's deed, or a deed given pursuant to a court order. Now, why I point that out is because if you get into another county, you're going to notice that their title examinations are much different. There are some counties that do 40 years. There are some counties that do 70 years. I'm sure there's other counties that maybe even have more. And it wasn't until recently that there were some counties that even required what we call a Holland Land Company search. You had to go back to the original point of origin where that title first started. Now, obviously, they were very expensive, and they were very thick with many, many notations in there. And so the rules were generally adapted to kind of take into account that, you didn't want to spend months putting together a title search for a very time-sensitive transaction. So you were able to sort of condense that down. Now, I was at a seminar one time where one of the speakers actually said that any abstract that was not a Holland Land Company abstract was called a truncated abstract. I had to look that word up. Basically meaning a search which was an abbreviated or a stub search which did not show the full title history. Now, if you got into that and you tried to solve every single title insurance and title issue going back almost over 200 years, you'd probably be spending quite a bit of time trying to correct those. So the abstract of title, again, we will get in a little bit later on what exactly they are and why do we do them and what's in them. One of the things I might, as we go down, number 7, requirements concerning New York State proceedings. Releases are usually required. Now again, if you've ever had to deal with maybe an Erie County attorney, you notice that they use a lot of affidavits to say that the state was not did not meet the New York State or federal threshold for needing a release of state tax. And generally that's accepted, I guess, basically because the amount of time it takes to get a release usually goes well beyond your closing period. Another thing I'll touch on, which is kind of sometimes a sore topic, number 8, mortgages. Now, mortgages are one of those items that no one really wants to deal with after the fact. And if you've done real estate examination, you know eventually you will get to a point where you've got a mortgage which is maybe not even your seller's mortgage. It could be 1 or 2 owners ago. So how does that generally govern? Well, obviously, in an ideal world, we go to the bank and we say, I need a discharge. The bank looks up their records. Here it is. Here's your discharge. We can continue along. But there are so many other little things, like a ball of yarn where you just pull on one thread and another unravels. We've got a bank that no longer is in existence, especially as you got into the banks that kind of went through the financial crisis of 2008, 2009, or a bank that may have gone through several name changes. If any of you have seen Empire of America or Gold Dome, you know what I'm talking about. Or you may get even a more dreaded one, which is the individually held mortgage. Now, most banks realize that when you pay off your debt, you're entitled to a discharge of mortgage. But if you've got a mortgage between relatives or friends or an acquaintance, oftentimes once they receive their last payment, they don't keep in mind that although they've considered it satisfied, the record shows it still be open. And so no one really wants to chase down someone who's moved to another state, someone who held the mortgage 10 or 15 years ago, or someone that no one knows what happened to them. And so these items govern in what cases it is acceptable to accept anything other than a discharge. You notice that there's proceedings. You can apply to a court. It's usually, from my understanding, very costly in both time and resources. I have seen it done on one occasion. I won't spend much time on this, but we had an instance one time where there was 2 brothers that held real estate, and it was sort of a mom and dad type farm. And so the 2 brothers kind of got an idea they'd like to sell the farm and split the proceeds. Well, unfortunately, once they got it listed by the realtor, the one brother had a change of heart, and he did not want to sell his share of the property. And so while the one brother was trying to have the realtor come out and prospective buyers come out, the other brother would chase them away with threats or aggressive behavior or any other means that he could do to scare them away. And in one instance, the record read that the realtor knocked on the door and could see the gentleman hiding under the table. So that's, if you really don't want to be, you answer the door, you hide under the table. Well, it was eventually settled that the one brother would buy out the other brother, and the brother who was basically going to be rid of the property would hold the mortgage. Well, as luck would have it, when the one brother finally did decide to sell the property, and he did basically pay off his mortgage, the offended brother refused to sign a discharge. He figures, if you can make it hard for me to sell the house, I'll make it hard for you to sell the house. And so these 2 brothers could not come, and so they had to go basically through court proceedings and get a discharge. So the moral of the story is get along with your relatives, because you never know when you're going to need them. Couple other points is the maturity date. Yes?
Just circle back to the state tax.
Yeah.
I mean, a lot of times around here, we get a release of lien in New York.
Correct.
How do you handle, just from a title insurance perspective, the federal situation? I mean, if you get a release of lien from New York, right, and the thresholds are less, are you satisfied at that point, or are you asking for
In most cases, we are satisfied with that. Now, obviously, you have to take into account the property, the value of the property, the assets that might be involved with it. It's very rare in this county to get one that actually meets the federal threshold. So in most cases, we understand it's a residential transaction. Most cases, it's a single-family house. It's been owned for so many years, and so we will accept the New York State release, and as a matter of underwriting, we will basically omit the requirement for federal estate tax release. Yep, yep.
Is there usually an escrow then, that you add in there as far as the closing costs? If it goes beyond closing?
Neil, do you want to come on that?
But on a release of estate tax lien? Yeah, what attorneys, the buyer's attorney may hold $500 just to sort of prod them. I think that's, even though there's nothing in the contract about it, that's generally accepted, holding some money.
There's nothing anywhere else.
No, just,
Practice.
Right,
just a
right.
common law. Standards of practice, I am making common law.
The other thing I was going to mention was the dating of the mortgage. Now, obviously, the borough rules state that any mortgage which was recorded more than 50 years prior to the day of closing can be disregarded if there's been no discharge, but there's some time practices. The maturity date. Now, back in the time you would look into a mortgage and you'd see that the mortgage came of payment on such and such a date, and so the clock kind of starts there from that maturity date. Now, in an ideal world, and we like to see this, those mortgages from the 70s and the 80s to have a maturity date, and then you can go to the calendar of 12 years prior to the date of the closing. Now, the mortgages that come out in these days, they don't really have the maturity date comes sometimes spelled right into that. And so at that point, you're looking at the 40-year. Now, where this becomes an issue is whether or not the buyer will accept the title under certain conditions. Now, there is a difference between what is acceptable sometimes to the buyer and what the title insurance is willing to insure over, and we'll touch on that when we get into title insurance. And of course, we sometimes have to be in the middle. We're the ones that, basically the seller says, tell them they don't need title insurance. The buyer says, I want title insurance, give it to me. And so we have to kind of balance off the what is necessary and what is required. And oftentimes, looking at the mortgages, they're spelled out right here. I've been asked before, can I use you as the bad guy for requiring the title insurance? And we got broad shoulders. We're willing to take on that role.
Randy, if
yeah.
I could interrupt just a minute, that, I think that the Bar Association did us a great favor with Section 8C. You just have to get the mortgage, and if the maturity date was more than 12 years prior to when you're closing, you get an affidavit from the seller saying no one's demanded payment. I mean, it really is an easy out for us. And a couple of years ago, I was looking at a search Hope gave me, and I saw this affidavit, and I said, what are they doing? What's this about? And so I was astute enough to look at my bar rules, and so okay, I guess she can do that. This is a great thing. So it really is a big help, I think, that Section 8C in helping us move things along. So, sorry, Randy.
And that's okay. No, I appreciate the comments there, Neil. If you want to flip the page, and again, I realize that I don't have a lot of time to touch on these, but I'm touching on issues in which we receive the most questions. Basically, is this a problem? Do I need to ask for more from the seller? I draw your attention, if I could drop down a few subsections to 15 regarding tax title. Now, when I was first title searching, basically tax titles were kind of like having the plague. You avoided them whenever possible because it just was a great big huge giant hole in the title. And of course, at those days, we used to run everybody, whether the tax title took place 30 years or 50 years ago, to date. And of course, obviously, the idea is that it sort of cluttered up the search and made it kind of unnecessary. And so we were able to condense that down. And so the question is what is acceptable as far as when you got that tax deed in your title search? Now, there's two, obviously, types of the tax title. And again, I won't spend a lot of time on them. But if you've seen a title search, you've seen ones which are the old style, which basically was just the tax deed and the legislative approval. And then, of course, obviously, you've seen the actual ones where there's the Supreme Court or County Court proceedings, the Article 11 tax proceedings where you've served everyone and everyone's got notice and you've cut off all their interests and got the court order and so on. And so if it's the old style, which is basically here's your quick claim deed from the county and go from there, the idea is that 30 years are required if there is no proceedings in that matter. Now, again, under the newer proceedings, Article 11, it's 20 years from the date of the deed given pursuant to the tax certificate. Again, this comes into a play a lot of times because it's sort of like we have some attorneys who say, hey, this tax certificate, it's still in the search. It may be more than 30 years, but still in the search. It's still a kind of a blight on the title, and so I want some sort of insurance or coverage on that. We have attorneys say, you know what, we got presumptive proof. We really don't want to have to provide the title insurance, and so 10 years, and that's good enough for us. And so it's very appropriate to have the bar rules spelled out, because then we can refer to them as a title company and say, well, this is what is acceptable as long as you've signed the contract that defers the bar rules of Jamestown. We can omit them from as a title defect. And then finally, yes.
Just touch on the title insurance.
Mm-hmm, sure. Yep.
This is an important issue for the title insurance.
Sure.
Title insurance. How do you deal with these issues when you haven't met the
Right.
requirements of the law?
Well, as you notice in the contract, one of the points under it says that the seller will provide what they call marketable title. So obviously, there's a good word for you. What defines marketability? If you cannot give the buyer marketable title, then in place of giving marketable title, you give them an owner's policy of title insurance. Well, when we do our title insurance for an owner's policy, we will insure titles as long as proper service has been made under the Mennonite notice, and we'll touch on that too a little bit later. We will insure titles that come through tax foreclosure as long as there's no obvious defects in the tax foreclosure process. And what we will do is say you have insurable title, meaning that you can pass this title along, but we will put in what we call a marketability exception. If you've seen one of our products, you notice it's about a 7-line statement which basically says that any future buyer will accept title insurance in lieu of having marketable title. So until that clock runs out on either the old tax proceedings or the new tax proceedings, we do what we call that marketability exception. They're basically saying, okay, buyer, you're not getting marketable title, and you have to understand that when you go to sell, and if you're still within that time frame, you will also have to purchase an owner's policy of title insurance, because we cannot guarantee marketable title at that point. So good question. That's what we do for title insurance.
But you will insure tax title.
That is correct. Yep. As a general rule, and again, we do look at the proceedings very closely, and I'll also try to touch on that a little bit more about sometimes the pitfalls that fall into when we see something that is less than perfect. But yes, as a general rule, they are insurable.
The tax proceedings, particularly in recent years, the tax foreclosure proceedings out of the county have been pretty clean.
That's correct. The county does their own, they actually contract out to the different search companies what they call the in-rem work, or the in-rem searches. And what they do is they rely on the abstracts to provide them with a list of interested parties so that proper service could be made. So in most cases, we have a very thorough system. So it's very rare when we find an actual defect, which causes us to take pause there. For one final note here, and I know I'm kind of running out of time here. Number 17, the proof of death. Again, we're talking about sometimes where you might be an owner or two ago, and no one knows where they passed away, or no one knows how to get the death certificate. No one really knows much about them. So in lieu of trying to get who were their heirs, obviously probate proceedings, administration proceedings, or proceedings of heirship are preferred. But oftentimes, as long as we can get affidavits of two people saying so-and-so died, and here were their only heirs that were entitled to the real property. And it is key to get those two affidavits. Sometimes we get the one, but the two affidavits from those who are familiar with the situation that says, yes, I can attest to the fact that this person died on such and such a date, and here are the people that are entitled to be their heirs at law. And then, of course, item subsection C in that 17, deed recitals, as far as saying that, for instance, we got son and daughter as only heirs of law of, John Jones, who died May 17th, 1984. And you'll notice here that it refers to Section 341. What that basically is we're looking for a deed that has a recital that's at least 10 years old. So if you're getting a deed in 2014 that says that these two people were the only heirs of law, well, that's not going to quite be sufficient. We're looking for a deed that's at least 10 years old that state those facts, that the people signing the deed are indeed the only heirs of the deceased. So, any questions on that?
So we're saying that's marketable or insurable?
As long as it meets these
It's
three,
marketable.
it's actually marketable, correct?
Okay.
Yep. Did you have any other comments on the bar rules? That pretty much wraps up my general comments on that.
Any questions?
Again, that 10-year rule,
Mhm.
is that something that's just standard?
It's actually according to the section of the law.
341.
341. I had to look that up from time to time because if you look at the bar rules, it doesn't say 10 years. So yeah, that's correct.
Real property.
I think that's universal as according as far as the, yeah.
They have their own set of standards. I tell you what, you stop by my office and I'll give you a copy, Paul.
I think Cattaraugus also has 40 years.
40 years?
Yes.
Yeah. Erie County's 60.
Yes.
Erie.
Yep.
Okay.
Do you want to talk at all about the New York State standards, or will you cover that when you do your?
We probably cover that because that's under
Okay.
the examination, yes,
All right.
yes.
Then if you would like to go ahead and transpose into the title insurance topic.
Okay, since we were just on title insurance, if you want to flip over to, let's see here. Basically, we'll be looking at the recommended practices under Section 5, I believe it is. So title insurance, it's one of those things that from time to time, we get the request for. We get a lot of questions about title insurance, and of course, obviously, as a title company, we have recommended practices as to how we write our title insurance. We don't just come up off the top of our head. We don't try to be creative, because when you get creative is when you get into trouble. And so oftentimes what we'll do is we'll defer to certain recommended practices of the New York State Land Title Association. And these standards that you see under Section 5 are basically what they require for us to do to make sure that the title insurance product is uniform and it complies. And so, again, I'll just kind of flip through these really quickly because, the meat and bones is the actual, the title insurance. You'll notice here that basically in general practices, the deed from the fiduciary, the delivery questions, those are important because obviously the essence of time is on our side, where, consideration, was this one of those ones where they're trying to get out from under some sort of financial obligation? Were they trying to cheat someone out of the, their share of the property? And so time is a great factor in that. And we look at that from a title insurance perspective. And what I'll probably do is, as I go through the title insurance list and the explanation of the two things, I'll touch on these from time to time as far as what we look for title insurance. Now, as we go through this, I'm going to kind of differentiate loan policy from owner's policy. If you've seen a title insurance product before, you've probably seen both a loan policy and an owner's policy, and you'll notice that there are some differences in the way that they're set up and the differences in the way that the coverages that they give. We obviously, in our small neck of the woods, see a lot more of the loan policies. Most banks are starting to require them more, as we've seen the different title traps going down through the years, and most banks, as a sort of a preventive measure, do order the loan policies to get the proper coverage. And the question I have from the clients, and we do get questions from time to time from lay people, those are sometimes the hardest to kind of explain to them, because we all know that everyone's trying to save a dollar from here and there, and so if they can kind of cut out some of the processes of the closing fees, they will prefer to do that. And so we'll get the question is well, why is title insurance necessary? The loan policy, obviously we insure it for the amount of the mortgage amount. So it's big or small, that's what we insure it for. Most of the coverage that's given for a loan policy is given to protect what is the value of what the bank has invested on that land. I think most of us would agree that banks don't usually give mortgages on just regular land, regular vacant land. They're interested in the improvements, because that's really where the money is. I mean, if you've got 100 acres of timber or something like that that's got value to it, that may be a different story. But most banks realize that they need to protect their investment in the house. Now, the client will often say to me, well, if the bank has ordered the loan policy, then do I really need to get an owner's policy? Because, basically, if they're satisfied with the title, I must have some coverage with that fact. And obviously, a simple answer to that is no, only the insured is covered under the loan policy. The name of the bank, oftentimes will get its successors and or assigns, meaning that if the bank should shop that mortgage out, the person taking on the obligation has the coverage as well. And that title insurance remains in effect as long as the loan is in effect. And it covers the bank. Now, the questions we get from the bank is, what can you give us to ensure that we don't have issues that affect the property of the house, rights of ways, or easements, or priority? We talked about the mortgages, and no bank wants to see that there's another mortgage ahead of them. That's the worst possible case. And so in referring back to the Bar Association standards regarding mortgages, what can we do short of getting a discharge of mortgage to be able to omit the mortgage altogether so that the bank has that first priority? And so, again, looking back there, oftentimes if it has met the requirements, we were able to omit those mortgages completely from that loan policy. Also, to be pointed out too is that the bank wants to make sure that they have priority when it comes to closing. For the most part, for title insurance, and I'm just going to point this out because this happens from time to time, if your mortgage is recorded with a deed, it is considered to be a purchase money mortgage, meaning that it has priority on the buyer against any other liens which he might have previously encumbered. So, for instance, if your buyer, say, for instance, had financial troubles and has judgments, and we'll get on the judgments also further down the topic, has judgments, those judgments will attach as soon as they take title to the property. So as soon as the deed has been delivered and they're entitled, those judgments attach. Now, if that purchase money mortgage is recorded at the time of the deed, that purchase money mortgage has priority over those judgments. Now, from a title insurance perspective, we would call them a Part 2 subordinate matter, meaning that they're still there. And they don't just go away because the bank's mortgage is of record, but they are considered subordinate items. Now, again, what that basically means that if the bank should have to foreclose on their loan, they already have a list of interested parties that they will have to serve as junior lien holders. And we're starting to see more and more in the title insurance industries that banks are starting to dig their heels in a little bit about those Part 2 subordinate items. It used to be the bank said, fine, as long as we've got first place, we'll take it. But I've seen on quite a few instances, and maybe you have in your practices, where the bank says, no, we cannot accept these subordinate items. You have to dispose of them before we can go on any further. And I think essentially it's a preventive measure so they don't have to chase these people on down the road if it should come to that. And so they look for that. Now, as far as to the improvements, oftentimes the banks will require some sort of affirmative language in the title insurance in their loan policy, basically saying that if you've got a right-of-way or an easement, that right-of-way easement will not interfere with the improvements on the premises. No one wants to find out that they built their house over the top of a utility easement that will later on have to be excavated to service that utility line. Or no one wants to hear that the person built their house on an openly used right-of-way that people are still using that might not have enough room to be able to access that. And so banks want to make sure that if there are rights-of-ways or easements, that basically that value is not going to be impaired by what's going to be found later on the title. And our role is to kind of plot those rights-of-ways and easements to make sure that they will not interfere. Now, we've all seen covenants and restrictions. We've all seen in more rural setting oil and gas leases. There's a coverage for that as well. The underwriters actually are starting to trend more toward using what they call endorsements to cover these matters for loan policies, whether it's the right-of-way, giving the affirmation that it will not interfere with improvements, or basically that the covenants and restrictions, if and will not be enforced, will not result in damage to the premises, and the same as goes to the oil and gas leases. Now, in comparison with that, going back to my first point, when someone says, well, if the bank is happy with their loan policy, then I should be covered as well. Well, the difference between a loan policy and an owner's policy is that the owner's policy ensures not just the improvements, but ensures the land itself. It ensures the value of what the purchaser, the purchaser paid for the land. That means every square inch. So there's a little bit more risk associated with that owner's policy, and we are required to kind of post up front. Now, again, we oftentimes don't get as many owner's policies in Chautauqua County because we all are very familiar with the lay of the land. We're familiar with certain parts of the county, whether it's a subdivision, whether it's a certain road, whether it's just basically associated with a historical name. And so oftentimes that's kind of disposed with, the contract, depending on what it calls for. Downstate, New York City, they actually consider it malpractice if the owner does not end up with an owner's policy out of the whole process. And that's kind of the difference between downstate and upstate. And so to kind of keep down on costs, oftentimes we don't see that is required. But an owner's policy ensures the value of the land. And why I say that, is that sometimes when you're at a closing, someone says, well, you know what, tell you what, the land is worth $75,000, but we really don't want to pay for a premium on $75,000 of coverage. And so what we want to do is we want to say, we'll insure it for the minimum. Let's just say $35,000. That way you still have some coverage, but we're not paying for it, the full-blown premium on an owner's policy. Now, we have to kind of remind people, unfortunately, while everyone's trying to save on costs, the rate manual does not allow us to underinsure premises. So even though you may be trying to be saving the seller a buck or two on it, the rate manual states that it should be insured for one of two things, either the purchase price of the property or the full market value of the property, whichever is greater. And that's something to take into consideration. And that way the owners can have that. Now, as far as,
I'm sorry,
Yeah.
what the premiums range from?
they basically start at $35,000. So anything that's $35,000 and under is a set premium, and then they go incrementally up from there. And you can,
How much is that, just so you can?
okay. So the base owner's policy for $35,000 and under is $303 at the current time. The way that the New York State has set it is $303 for an owner's policy. And again, above $35,000, it goes up incrementally. Sky's the limit, so to speak. So, yeah, that's a good question, because some people do ask, well, how much is this going to cost me? I've already paid for title search. Do I need to really also offer title insurance? Now, title insurance, again, for an owner is necessary if there's a marketability exception or a certain defect in the title, such as a title gap, which we can insure over and issue that as well. As far as the term of the owner's policy goes, the title insurance extends for as long as that buyer, owner, owns that property. So I get questions, well, is this like a premium that you pay, like on your homeowners, your car insurance, and so on and so forth. And no, this is a one-time premium that's paid for by the parties as they arrange for it, and it is good for as long as the owner owns that property. Now, there is such a thing. Yes.
Excuse me, Randy. So John Smith buys the property, gets the owner's policy. 3 years down the road, he gets married and puts his wife, Mary Smith's name in the title. Is the owner's policy still in existence?
Yes, and I'm glad I was just getting ready to go on to the extension of the owner's policy. Yes, as long as the owner continues to own the property or sells it into him and an affiliated entity, or sells it to a family member, a child, or an affiliated trust or partnership or something like that, the title insurance continues. Now, the idea here, when defining when is title insurance extended, it must be to a related entity, and basically a family member, and it must be for zero consideration. Where this comes into play is a few years ago, I had a father who wanted to sell the property that he owned to his daughter and son-in-law, and wanted to know if he could continue to pass the title insurance along to his daughter and son-in-law. Now, there was 2 strikes against him from the very start because, number one, the son was not considered to be blood relative. It should be placed only in the name of the daughter, and then that way the daughter could have that extended coverage. The other wrinkle to that was that the father was actually going to get consideration on that family transfer. And so I think it was a nominal amount, but that disqualified it from receiving that extended title insurance. So yes, if your client says, hey, I want to transfer this property to my children or put it in the name of my trust, I did have an owner's policy, will it be necessary to order title insurance or pay the premium all over again? And for the most part, it can be stated that that title insurance premium is still in place. The title insurance is still effective. Now, again, you'll get into the point where you might have family members, several family members, maybe several sets of siblings that own the property, whether it's a valuable lake property, and they'll decide that maybe these 2 couples want out and they no longer want to be entitled to the property. And as long as they either transfer it to the other 2 or, again, family members, they can do that and have the title insurance continue. But if they decide, you know what, I've got a neighbor who's interested in having a third interest in this property, I want to sell my property to them, and it breaks that title insurance up. And so the idea is to try to keep it as closely as possible. And so that kind of defines the owner's policy. I know this is kind of a very much an abbreviated discussion of title insurance. Kind of, if you went to college when there still was paper, you know, such thing as Cliff Notes, when you couldn't read the whole book, you just read the Cliff Notes. Sam, did you have a question?
One question on the
Yep.
access. Can you speak just for a second, again, in the title insurance fee owner's policy context,
Right.
is access insured as part of the normal?
Yes, yes. That's under what we call the boilerplate. So if you have a fee policy in front of you, obviously you pay more attention what's in the middle, which is the name of the insured, the amount of the insurance, the exceptions to title, and things like that. But if you look in the boilerplate, which is those tiny little, the small print, so to speak, what is covered and what is accepted under the boilerplate, access is automatically insured on an owner's policy of title insurance. Now, that puts the burden on the title company to make sure that there's actually access. Because even if you're silent and say, well, if I'm silent about the access, even though I'm not quite sure of it, you know, we're covered. But if being silent, by implication, you have access. And so what we have to do as a title insurance is actually make sure that you've got coverage and that you've got access. I'll give you a couple specific examples. You might have a piece of property that's right smack dab in the middle of a puzzle, so to speak. It's not abutting on any roads. We have no physical or known right-of-way that leads us to the property. But as it turns out, the person who's buying this chunk in the middle of nowhere also owns the front piece, which does abut on the road. Now, we have to be very specific even though it does not abut on an open public road, because the access is insured under the policy, we have to go in and say that basically access is insured, basically in a paraphrase, under premises that are already owned by the owner. So the owner can't say, well, I've got a road to the north and it's across my neighbor's property, I'm going to get across it that way. The idea is that if you bought that property, we're willing to insure access simply under the idea that you also own the front half. And as long as those two pieces go together, then we're willing to insure that. Sometimes the right-of-way or the easement is not the most convenient. I've had times where we got two driveways. One's a nice 100 to 200 foot driveway that goes to the side road. The other one's a nice, convenient, quote-unquote shared driveway that we kind of go across the neighbor's property, and it's 15, 20 feet from the road, and that's really the more convenient way to go. Now, unless you get the neighbor to sign on to this easement to say, yes, I will give you unrestricted access to the property, having the neighbor's permission to say, yeah, as long as you own the property, it's all well and good, but from a title aspect, we look for something that's obviously more concrete, something that's recorded, something that's been signed on to. And so even though you may want to use that gravel driveway of your neighbors, if it's not covered under any kind of an access agreement and you have no other access, we have to say that the title is insured under an access agreement or an access on this other property, which may not be convenient. But it's not so necessarily what's convenient, what is that legal access. Yes?
How do you know if you're looking at title search down the line if there's title insurance on there? How is that represented? Is there a policy actually delivered to the owner? Is it reflected anywhere in the title search?
Yeah, well, I can basically speak from, Chautauqua Abstract's viewpoint. If you get one of our searches, and of course, obviously, you have certificates that make up the title search, we'll cover that as well. What we will do is on certificates that we've insured title, we will put at the very tail end where there's the dating page, you'll see a signature page and a date, we will put a stamp there. We will say insured by, whether it's Fidelity or Stewart or First American, and then we will put the policy, the title number, and stamp that right there. We've done that probably since at least late 70s. Obviously, we've insured properties in Cattaraugus County because we do have a sister company over there. We're able to access their search products to put that stamp. We do go as far as Allegheny County. Now, we don't have as much control over the search products, so a lot of times, if you don't see that stamp in another county, really the only other way to do that to ascertain is to ask the seller, did you get a policy, whether it's a loan policy or fee policy, when this property is purchased. But if it's a local, Chautauqua County, Cattaraugus County, it's identified by a stamp. I have noticed that there are other companies that will do that as well. They'll stamp there and say insured by title number, and that's kind of really the benchmark that we use to determine. I guess it depends on what's in that policy. We will get buyer's attorneys will ask for a copy. We do provide copies of, if it's not available to them. We have provided before in the past policies so they can review the title, see what the exceptions of the title are, so they can kind of cut down on the examination time. So yes, yeah, we've done that before.
Thanks, Randy.
Yeah.
A little trivia for you here. When John Ortendale was working with us to compile the materials for your course book, several of us were of the impression that the latest version of the New York State Bar Association standards were the 1976, I believe it was, it's referred to in our Jamestown Bar Association standards. But we did find out that there was an update to the New York State Bar Association standards, and that was done in July of 2005. That's the standards that are in your materials. And if you take the time to read the New York State Land Title Association recommended practices that Randy just went over, they're identical. There's probably two very small variations. So now the New York State Bar Association standards for title examination and the New York State Land Title Association standards are basically the same. Let's see. The title closer's checklist that's in the materials, that's just for your own edification. We're not going to cover that. It's a useful guide if you're new in the closing world, and just helps you to make sure that you've covered all of the important aspects. So feel free to use it, but we're going to skip by, and Randy is going to cover the topic of abstracts of title.
Okay, thank you, Hope. Yeah, if you want to turn over to section 7, this gives you kind of our title search outline, what a title search is. Again, I could spend volumes of time on title searches, what they are, what they do, what they look like, the purpose for them, and again, I have to kind of give you the abridged version of that. I want to start out the discussion because it's kind of interesting to note that when we do get inquiries from a person who owns a piece of property or a person who is interested in buying a piece of property, why do I need a title search? Now, oftentimes we get this question because, again, it's a vacant piece of property. We don't really want to spend money on a title search. We don't really spend money on a closing cost. We just want to make this quickly and as cheaply as possible. And so if I can give you really quickly the top 3 inquiries I get from clients from time to time, and maybe you've heard these before. Number 1, that the property has been in the family for generations, so therefore nothing could be wrong with it. Number 2, property is with a neighbor. He's a good guy, so he possibly couldn't have done anything to the property to encumber the property. Number 3 was the property has gone through either a mortgage foreclosure or a tax foreclosure, so therefore the bank/county has already cleaned it up, and so title is good. Those are the assumptions that we get when we get to title searches. Now, each one of those ones kind of make us chuckle a little bit because we all can tell stories about times where those 3 main reasons went very much awry. Really quick example of that. Property has been in the family for generations. I had a deal a couple years ago where it was 3 generations of farmers. Unbeknownst to the buyer was that the property had been split into 2, there was 100 acres of farm, had been split into 2 50-acre parcels that were shared among the sons. Well, lo and behold, this is the backstory I got on this, late 30s, early 40s, the one son, his farm burnt to the ground. And so he was so discouraged by that, he basically abandoned the farm, moved somewhere out west, and that was the last anyone ever heard of him. Well, the son that remained basically adopted the property, if I could use that word, and used it as his farm. Now you look at that and you say, well, yeah, he's been farming that, been his crops, not realizing that when the brother left to go west, he never gave a deed to his brother for the property, and so we have this outstanding interest. So from the casual look, everything appeared to be okay. And so the abstract of title reveals the fact that, yes, you've got a hanging interest out there, or maybe the neighbor that you thought was in good standing has a couple skeletons in his closet, or as far as the foreclosure goes, maybe in the rare instances, the bank or the county actually missed whether it was an interested party, whether it was an owner, a judgment holder, or a mortgage holder, and they were not properly served. And so the title search reveals that. We've gotten much better, if I can say this, and I think we can all attest to this, with the collapse of 2008, 2009, with the banks being held accountable to run a proper foreclosure service. It used to be back in the day that, that we called them the foreclosure mills. You just do them as quickly as possible. You run them out like in cookie cutter fashion, and hopefully you got everything. But from the title company, the abstract company, we oftentimes found that there was generally holes in that title. So basically, covering really quickly why the title search is needed, I go into the abstract itself. Now, you're familiar with it. It can have a variety of colors on the front of it. but they pretty much all look the same. To the person who looks at it, it kind of looks like a, some sort of a brochure or something on how to better your life. Instead of folding like a book, it folds open like a pamphlet. So when you look at that, you say to yourself, well, this is the abstract of title. Now, there is a reason why, back in the day, you used to see those stickers that were put on the abstract of title. Valuable document pertaining to real estate. Please keep in a safe place, or please keep with your other real estate papers. And why that is, if I had a story for every time that a search came in, looking like it was either A, left under the water cooler or the water heater in the basement, or B, used to prop up the table, or C, kind of kept maybe in a very damp basement. The idea is most people think, it's just another document, let's put it somewhere. But the abstract is very important because it is a story of the title history. In the days, the formative days of the county, when travel was much more difficult, if you were to have a real estate closing, you had to go to the courthouse and look at the record yourself. Those old handwritten deed and mortgage documents, lien dockets, a check of the tax certificates to make sure everything was okay. Well, can you imagine if you had to do that with every real estate transaction, you would not have time for anything else. But in our modern world, it can be accomplished very quickly in a very concise and effective manner. And so what that does is it saves on time. It is a representation of what that title history looks like. And each certificate, if you're familiar with the title search, is a chapter that is written in that title history. And you'll see the periods that are covered, whether it's a 10-year period, a 20-year period, and it is basically a compendium of what took place during that 20-year period. Now, as the attorney is looking through that, now you can look at recent title history, but you can look at past title history just to make sure that the title flows. And so as you sit in your office, rather than have to go up to the county, you rely on the fact that everything's been laid out for you. It is a general search of all records which would pertain to real estate. And so as you look through the search, you'll notice that oftentimes there is a different colored certificate, whether it's canary yellow or maybe a gray color or something like that, which is a summary of the tax title. Now, referring back to the bar rule standards, which I referred to earlier, what is acceptable is a 10-year tax search period to make sure that taxes are paid for that time period. Now, we realize that most taxes, if they're not paid within a couple of years, go for tax foreclosure, but there are some instances where taxes can linger, whether it's a property which is going through bankruptcy, whether it's a property that might have some sort of hazardous waste issue to it, where the taxes extend out even more than that. And so in looking for that, it's good to keep in mind that that 10-year tax period extends beyond the 2-year window to kind of cover that 10-year period there. You'll notice in sometimes the searches, we will still set out tax foreclosures that are much older than that 10 years, but it's basically done just to kind of give a smooth flow of the title. So you say, well, why do I have this interim proceeding from 1964? That's so old, why do I need to be concerned? But it basically continues to tell the story that it went from person to county and then back to a new individual. Well, what is the title search? We mentioned again, it is used for examination purposes. It is used for the attorney to be able to give an opinion of title, a certificate of title, which states I have looked at an abstract and I've been able to give a good title opinion. A title search can take many forms. We're all familiar with an original title search that goes back to that 50-year period we talked about earlier. Sometimes if you get a rare gem, you might have one that goes back even further. And on some instances, you might even get one that goes all the way back to the Holland Land Company. Oftentimes, those are the ones that the county clerk does, that were written in pen when the county clerk still did searches. But just to kind of bear in mind that depending on the contract that you've signed, you can also ask for and receive what we call a certified copy. Now, I will put a little bit of disclaimer there. It is very important to pay attention to the contract that is signed. Because in the North County, if you signed an Erie County contract for property in Chautauqua County, you will play by their rules. You're in their sandbox. It is interesting to note, and I'm not sure in every case, but in Erie County, they do not accept certified copies of abstracts. And so if you say, oh, I'll just give them a certified copy, and that's the most efficient way of doing it, it may not be accepted if the Erie County attorney says, nope, it's on an Erie County contract, so I'm requiring an original title search, and that can take many different forms. But oftentimes, it is available as a certified copy, as long as it's original certificates, not a certified copy, someone else's certified copy. It has to be original certificates that the copy can be provided for. One of the things is what is a title search not? Again, I will refer back to some stories I received from individuals who will call from time to time and try to order a title search to cover some instances where they feel safe. The first thing is that when you read a title search, when you look at the very first page, what we call the certificate, there are guarantees that you'll see in there. Those guarantees do not apply to the title itself. So when we say we guarantee what we find herein, it's not guaranteeing that you got good title. It is guaranteeing that the search is an accurate representation of what is filed in the county clerk's office. And those guarantees are important because obviously you don't want to go back to the title company years later and say, well, you told me that everything was included, but lo and behold, the buyer's attorney found a mortgage somehow that was missed in this title abstract. The guarantee basically says that we cover those omissions. We cover the fact, and we will tell you that we've done an accurate representation of replicating what's in the title, the index to the county clerk's office. But again, it does not guarantee the title is good. If you say, well, look, the title company says, hey, they guaranteed everything that's within this search. It applies to the paper, but not necessarily to the concept of the title itself. And so we are the person, we are the bearer of bad news. It's up to you to figure out how to fix that. Yes, Sam?
One question, can you describe what the distinction for your typical search in Chautauqua County, and what's often referred to in other areas, premises only?
Yes.
It's a little different animal. Maybe
Yes.
you can touch on that.
Yes.
What's the distinction?
Premises only search, and again, that's a very familiar term with in Erie County. They examine what they call premises only searches up there. Now, if you have a typical title search, you'll notice that it is basically what we call a devolution of title. You start with the bigger piece, and then you kind of shrink it down to basically what you're interested in. Now, oftentimes, if you are ever in a hurry, or if you're short on time, it's often tedious to go through that title, which deals with the 100 or 200 acres, and have to wade through, leases that are old or rights of way that affect the northwest corner of the premises. And so, to save on time, what is often ordered is premises only searches. The title company at that point will basically condense it down to its rawest form as to what affects only the premises. And so what they'll do is, rather than resetting out those cumbersome descriptions, whether it's long paragraphs or multiple paragraphs, they will basically abstract that to say, yes, that the premises in question is what we call it, are covered. We'll call that with other lands premises in question, or premises in question and more. And so rather than having to spend your time trying to plot it, you look at it and say, okay, the abstract company has plotted that for me and said, yes, you can rely on the fact that this deed is premises in question and more. What we will also do is we will try to weed out those encumbrances which do not affect the premises. So if your property is in the southwest 5 acres and you're on Jones Road, if there's a right-of-way which is actually on the north corner of the property, which affected the property in its whole, we will omit it because we can point out and say, this specifically took a piece of land which is parallel to Smith Road, which is on the north, and so therefore we as a title company, as an abstract company, can omit it so that the product that you get is not the nuts and bolts and the kitchen sink. It is the bare minimum of what we can say this affects the premises. Now, unfortunately, It doesn't always work out perfectly. You might get those what we call blanket easements, where the utility company has a specific spot in mind, but they don't bother to share that. And so it's a very abbreviated description, which might refer to it as all lands owned by the owner, by library and page, which also covers us. Or they might say north by so-and-so, east by so-and-so, west by the lot line, south by the road. And of course, that's such a wide, if you can't pin that down, it is in there as well. But yeah, the premises only searches are, again, basically made so that you as the examining counsel can say, give it to me in its most condensed form. So that's,
Excuse
yes,
me, Randy.
yeah.
Now, speaking about easements, just for some of the younger lawyers, if there's a specific easement saying a gas line's going here, and the easement's from the 1960s, 1970s, you have to be cautious because that doesn't mean the gas company put the line there, okay? They may have put it where it's easiest to put across that property. I had a transaction where we're supposed to be along a road in the lake, and instead it was at a 45-degree angle, a couple hundred feet north of that. So my client was building a garage, and the gas line was right underneath it. So they take shortcuts, so just be careful of that. Sorry.
Yeah, that's fine. The other thing I want to point out that an abstract is not, it's not necessarily a mapping tool. Now, I've had an individual coming off the street who said, now, if you're familiar with the abstracts, typically speaking, Chautauqua County, we offer one of two variations, which is either a plot plan, where the abstract company has actually plotted the dimensions. The purpose of it is to aid in examination, so you're not trying to plot it on a piece of paper or on your calendar. It is there to say, well, look, here's where the lot line is, here's where the road is. This is a general idea of where the property lies. Or, in the absence of a plot plan, you're familiar with getting maybe a copy of the tax map, whether it's the old tax map or the new tax map. And again, that's an idea of this is the general dimensions of property. Oftentimes people look at those and say, oh, so this is the survey of the property. This is basically tells me where my dimensions are. And one gentleman came in to me one day and said, your plot plan shows I have 60 foot of frontage on the road. And I believe I have 80 feet frontage on the road. And I had to remind him, well, that's basically dependent on what happens when a surveyor goes out there. We go by what the record shows. So if the record shows the dimensions as being 60 feet, that's what basically that plot plan is used for. It is for information purposes to give you an idea of how that line lies, but it's not a survey. So if you order the search thinking, hey, this is where it shows my property to be, you might be mildly surprised to find out that a surveyor finds that not only is the property different when it's actually physically measured, but also too that there might be some encroachments to watch out for, or as Neil mentioned, the actual locations of rights-of-ways or easements. And touching on utility easements, there's also a great variation sometimes if there's an agreed upon access point where it should have been and where it ended up being, and that's sometimes based on the most convenient point as regards to the lay of the land. And so a survey might show that the right-of-way turned out to be in a different spot than what the record shows. So it is not a survey. And then the final thing I would point out, too, as far as an abstract goes, it is not to be used to determine the age of the improvements. And again, I've had people call me up and say, my great-grandfather built this house, and we're trying to figure out how old this house is. I want to order a title search. Well, the title search deals with what's in the clerk's index. And so we are not physically aware of the physical improvements. Now, there are some cases where we can give clues as to the age of the house, one of two ways. Number one, obviously, if you have a construction loan, that's usually a very good indication that obviously improvements were put up at that time. Or if we have access to the clerk, to the Department of Finance records, you'll see a jump in the appraisal. So whereas you had a $15,000 piece of property, and suddenly in a year or two it jumps to $75,000 or $80,000, again, if they did a reappraisal of the land, discovered there was an improvement on the land, they can do that. But as a general whole, you're not going to It's not a pop-up book. You're not going to turn back and suddenly the house springs into motion. So it is not to be used as a tool to try to determine when that property might have been built. And so that oftentimes has to deal with that. The title search itself, again, shows property, deeds, and mortgages. And we establish what we call to do a chain of title. The idea with a chain is that it is a link from one owner to another. And what you want to do is see a clear transfer of property, whether it's by deed, or whether it's by estates, whether it's by a passing of a will, whether it's by an administration, and again, it's in your material there, how it can be transferred. What you want to see, though, is a clear chain of title. You don't like to see that break in the title where suddenly you're person A, and then person C surfaces, and there's no explanation as to how they took title. And so that's basically what the title abstract is. I know I didn't really cover the whole realm of it, but if you have any questions, I'd be more than happy to answer them.
How do you determine whether to do a plot plan or not? Is that just discretionary with the abstract?
That's a very good question. When I was a title searcher, I had two very good teachers that taught me when to use a plan and when not to use a plan. For those of you who are familiar with Chautauqua Abstract, two names, Willard Morton and Connie Zenz. And I'll never forget Connie Zenz. I remember very specifically when I was a searcher, I tried drawing a plot plan for a property that's in the village of Forestville. Now, I don't know if you've ever had opportunity to deal with property in the village of Forestville. Thinking that it's in a village, you're thinking that everything is nice and rectangle. Let me just tell you this, it is not. I don't know if there are any rectangles, I could be wrong, in the village of Forestville, but one time I had this particular one that it was an odd-shaped piece and went by neighbors' properties, no fixed points, and so I basically drew this very good-looking plot plan. And Connie Zen said to me, if someone came up to you and said, how did you come up with this plot plan? If you cannot come up with a good answer, you shouldn't be drawing it. And so that was my idea, that when you cannot positively affix the location based on, again, the carpenter's mill or the blacksmith shop or the oak tree or the rock, then oftentimes you defer to where does tax map have this plotted. Willard, I mentioned him also too. The one time I drew a plot plan and one of my boundaries was the railroad. Well, unless I want to dig out that railroad map and show how it basically wound its way through the lot, just randomly putting that railroad line anywhere I wanted to did not qualify it as a sufficient boundary for the plot plan. And so he said in that case, unless you, again, want to spend hours or days tracing the railroad from north to south, you were basically relying on the mapping authority as to where they had that railroad. So if you can't positively identify it, we defer to that tax map as a main means of giving you information about where it is located. Good question. Any other questions? Yes, John.
When is it good to use the historical description versus a new survey description? Is it always good to use both?
The historical description, we used to have in those days, and again, many of you can sort of kind of attest to this, that there was a day when you tried to consider what they call continuity. If you're reading a search, and the abstract company is certified to number one, you like to see that they've always used number one to certify to. That way you know that the product that you're getting at the tail end is the same product that's often certified to. And oftentimes we would ask, especially in the mid-60s, I wasn't there in the mid-60s, but I've been told that in the mid-60s we were asked to say that if we were going to change that description, say from a historic description to a newer description, that we would say premises in question conveyed by one, as more modernly conveyed or as more recently described by number 10. You were building a bridge from number 1 to number 10. Now, the onus was on the abstract company to actually make sure that was the case. You didn't want the attorney to rely on that when suddenly you realized that you were feet off or the angle was completely different. and the property looked nothing like that. And so we've always kind of deferred to the historical documentation for that. Now, it is good to have that continuity in a title search, but I can tell you from a title insurance perspective, that's not always ideal. We go back to descriptions, and maybe I can kind of kill two birds with one stone here when talking about legal descriptions. From a title insurance perspective, it is difficult to put your feet in the ground or to put your stake in the ground when you either are have those impossible descriptions which are bounded by monuments which may have existed 100 years ago, but how many oak trees live 100 to 150 years? Not too many. How many blacksmith shops do we still have in the area? Maybe if it's a hobby, but not as a general practice. And so when you base your boundaries on those monuments which may no longer exist, from a title insurance perspective, that's harder to insure because you have to be content that you're insuring those boundaries exactly as deeded. The other thing too is dimensions which may have fixed points, but which may be dependent upon neighboring properties. I think back to another search that we did that was in the village of Sherman. And in Sherman, everyone's property is based on their neighbor's property, which their property is based on their neighbor's property. You can see where I'm going with this, that it's kind of like a general cycle of having to go all the way back to the intersection of a road and then build your case neighbor by neighbor to certainly identify that your neighbor is in that location. Because we do have some cases where the property is thought to have been is a lot different than where the property is actually occupied. And so if we get a property where it's bounded by neighbors, we can kind of defer to saying to our searchers, you need to build a case so that if we're going to insure this property, we can identify these neighbors. And then, of course, the last and final thing is that none of us want to see are tax map identifications. Again, I could keep here 2 hours on different kinds, but we discourage the use of tax map identifications, obviously, because they can change and oftentimes they're not fixed. And lo and behold, just to kind of give you an idea, the county clerk will not accept tax map numbers when conveying title. Now, it's okay for them to use it when they're doing the tax deed or the quitclaim deed from the county, but if you try to continue that into your next owner, they will not accept that deed from that owner. It has to be a good perimeter description. We all know, if you've had any experience, that there used to be once upon a time town of Bustye tax map system, which changed over time. There was an old city of Jamestown tax map, which has changed over time. And so descriptions which use those are harder to plot because those maps are no longer applicable. We have now changed over to what we call a new GIS grid mapping system. So even our more recent tax map numbers no longer apply. And so the idea is, although that's been used in conveyances in the past, you want a more modern description. I kind of digress there, but kind of looking at a viewpoint, if you're content that the historic description which you're using adequately describes the property within reason, that is a property that's going to be insured. I mean, we obviously, we're spoiled. We all like to have the new surveyor descriptions, and in that case, because they're more precise, the angles might be changed a little bit differently, but from an aspect, as long as you feel comfortable that you can plot that description within reason, we can insure those historic descriptions. Yes.
From a title insurance perspective.
Yep.
Thinking about it. And following John's point, sometimes you get in late properties and so on where there's a number of feet different. I mean, it's,
Correct.
it can be not just a couple inches. So there's a fairly, discrepancy.
Sure.
Between the new survey
Yep.
and the old historic work that you look at.
Yep. Yeah.
How do you think about that as far as providing insurance? What do you like to see? I mean, the more modernly described ads, having more modern, up-to-date survey. And how do you policy ensure that?
Yeah, that's a very good point. We all know what accretion is, and we all know what, when the kind of lake subsides a little bit, that it can change over a number of years. Not just the lake, but if you're bounded by a creek or a river or a stream, that can change dramatically as well. We've not really had any problem. Obviously, the more modern description gives you the lay of the land as it exists currently. Well, how we deal with that, if the parties are okay with using the more historic description, obviously the call goes toward Chautauqua Lake. Now, whether it goes to a certain point and then 15 feet into the lake and then along the lake bed, or if it goes even more than that, we've insured them before. Now, what we will do, and if you've ever had one of our lake title insurance products before, you will notice that we will put what we call an exception in for that lake, meaning that as the lake gains land or loses land, we basically insure to the high water mark of that body of water, that we will not insure, land beyond that. Some people, you will note, as the lake subsides, they will try to develop that more. Obviously, it's not recommended that you build any kind of improvement on there, but they may gain more land. And so what we do, we use a description, obviously with the caveat that that description will change over the years. And so as that land changes, whether it's by due of nature, whether it's man-made, whether it's by the government, we will still insure that description, with the exception that there may be land that goes beyond that high water mark that's not insured under the policy. And so whereas you might have as much right as anyone else does to that additional land, it's not necessarily insured. So your description is insured, but again, to that high water mark. Yeah.
And the description that is insured, so you've got an old historic description, then you have a more modern description, the surveyor brought it, and it's 2 feet different. So are you insuring, what area, are you insuring both descriptions?
When we come down to that, when it's a matter of we've got a more modern description or we've got a historic description, again, there's exceptions to every rule, but we would tend to insure the more modern description because, again, that's a more relevant, a more current description of the property. When we give title insurance, you look back and say, well, this is quite a bit different than what the search has in the historic description. Yeah.
Getting back to John's question, how about using the surveyor's description and then putting at the end of the description being the same premises conveyed? Was that?
That's always appreciated. What you do with that is what we call the intent purposes. If you've got a historic, more modern description and you put that in there, you give yourself a little bit more insurance. That even though it may look a lot different, again, based on the changes to the land, based on maybe some boundary line changes, based on some changes, again, forces of nature, that the intention is that the land is the same. And that's sometimes accomplished in two different ways. One is the historic description and then the more modern description. And then one is the modern description with the intention of it being the same premises. Now, we kind of defer that to the comfort of the parties because you're asking the seller in most cases to sign a warranty deed. There are some sellers who basically say, I will sign a warranty deed for what I got. If you're changing the description on me, you're asking me to warrant title to this new description. And we have instances where the seller says, I'm not comfortable with this description. So then the suggestion is, well, we will put in that more modern description, but basically you're covered by the fact that the intention is it reverts back to that historic description. And so even though it might be a little bit off, the idea is that the property and its occupation lines and things like that is still the same. So we recommend that.
So in the title policy then, do you describe the new description and then also put that clause that it's being the same premises?
If it's in the deed, we will put that being the same premises as. Now again, there may be some parties that are not comfortable with putting that clause in there. We will still ensure the modern description. Again, it is on us to determine that it within reason, the same premises. We don't blindly just ensure premises because, the description has changed. But if we are content that the description is still within reason, within the bounds of the historic description, we will ensure the more modern description. And oftentimes, if we are asked the preference, we prefer the more modern description over the historic descriptions. And maybe you've gotten phone calls from the title company because the deed has the historic description, deed has the modern description, but lo and behold, your mortgage, because the title company gave you the historic description, has the old description in it. And so you may get a call from me or one of the other title companies saying, would it be okay to switch the mortgage description, even though we originally had it in our title commitment, to match the deed? Number one, because the deed and the mortgage will match, but then we're kind of all on the same page. Deed, mortgage, title, insurance match. And so we oftentimes prefer the more modern description.
Thank you. When Greg said that he was going to allow us a couple of hours to cover this, I thought there's no way we're going to be able to fill up 2 hours with this basic stuff, but as you can see, we're halfway through our agenda here. We're going to skip over the deed forms. Those forms and their instructions are in your materials. I wanted to mention that a few years ago, our real estate committee did also promulgate a mortgage discharge guarantee agreement. I'm sure that many of you that are here have heard Frank Carroll speak. He's been a speaker here many times, and he is with a title company, and he has indicated more than once in his presentations that a mortgage discharge guarantee, which is what I think many of us have used for years, is really a pretty meaningless document. And so after one of his presentations where he made that statement, our real estate committee did work together on preparing a mortgage discharge guarantee agreement. And again, it would be available to you on the Bar Association website, but I would encourage you to be using those in your closings. What it does is number one, it puts the onus on the seller to make sure that the mortgage is discharged. The seller is the one that is guaranteeing that it's going to be discharged. The seller's attorney is agreeing to take certain steps to make sure that the mortgage discharge does get recorded. And then the purchaser signs as well to acknowledge that they're willing to close the transaction without that mortgage discharge being available. So I'm just giving you the real basics on that. But that was something that our real estate committee spent a good deal of time working out and coming up with the form. We also, in your materials, have given you dates for the real property tax and the lien duration. So those are in your materials, so we won't spend too much more time this afternoon on those. The villages and the cities do also have, in some instances, utility liens. Again, we won't spend a lot of time covering those, but be aware of those when you're dealing with property that's located in an incorporated village or in a city, that to the extent that those municipalities do offer public utilities, that they do have the ability, if the utilities go unpaid, to eventually add them to the tax or as a lien. Neil, we'll go to you now and have you cover briefly concurrent ownership. We have about 5 minutes.
Okay.
Okay.
Getting back to Randy's point, I remember on lakefront properties, my in-laws had a big old lakefront house in Bemis with 100 feet of lakefront, and it was a break wall. And in August came and the grass would dry out because it was dry. You could see the original break wall, which was 30 to 40 feet back from the new break wall. So that was all added land to their front yard by somebody back years ago. So those things happen. Concurrent ownership, pretty straightforward, as you know. If the deed just gives title to Two people, doesn't say anything else, are deemed to be tenants in common. Joint title with right of survivorship. The one thing I had forgotten and caught getting ready for this is that in order for people to have a joint title with a right of survivorship, they have to have equal shares. So you can't have title 3/4 to John Smith and 1/4 to Mary, or to Mary Brown, and have them as joint tenants with a right of survivorship. They have to take title at the same time by the same instrument, and their shares have to be equal. Tenants by the entirety, husband and wife, it doesn't need to say it on the deed. It's deemed by law. Obviously, you're better setting it forth on the paper itself to make it clear, but they are deemed to be tenants by the entirety if they're married, and if so, one passes away, it's a joint, just like a joint tenant with a right of survivorship. The other one automatically takes title, which it can be important with respect to if there's any liens against the deceased individual about whether they survive or not. Life tenants, we see a lot of that. People, when they get up in years, they deed the property to their children, and they keep a life tenancy in the property, which entitles them to exclusive possession and control of the property during their life. It also obligates them to maintain the property, take care of it, and not cause waste on the property. And so in our title searches, when we see that, we have to make sure that we have death certificates for anybody who reserved property as a life tenant. Although in our title rules, I believe if the life tenancy was more than 75 years ago, we can presume that they are deceased. Okay. The remainder men and the children, I think one of the things you need to be careful when you're advising clients is, I'm sure you're all aware, you tell them, when you do this, there's the chance that one of the children can run into financial trouble and have a judgment against them. And so even though that, to the best of my knowledge, is not going to in any way dispossess you of the property or cause you problems upon your death, it could. Some attorneys do trusts to avoid that, irrevocable trusts, where they put the property in the trust for the benefit of the children. One advantage of doing that. I don't know if there's anything else we need to discuss on that.
I think
It's all pretty basic.
Talk for a minute, if you would, Neil, about the requirement of having the funds
Yeah, that's the
available
note.
to
Note
you.
Hope has told me twice and gave to me at this point. There it is, right in front of me. My paralegal was out of town last week, and I called her asking her for a corporate book, and she said, "Are you at your desk?" And I said, "Yes." She goes, "Look to your left." And there it was. Yeah, one of the things we got to be careful of, when we're representing buyers, before we record the deed, make sure we got the money in our trust account, or we got the obligation from the bank that they're going to make it available that day. Got to have it. Nothing worse than recording a deed and having not have the money or have the lender pull out, and then you're calling the abstract company and saying, "Can you unrecord this?" Not good. And make sure they're good funds too. Years ago we used to take the client's check, and you got to have a bank check or cashier's check. Got to turn your clients. Some of them get insulted, particularly the older ones. Just what? My check's not good enough. But just explain to them we got to be able to, under the banking rules, turn that money around the same day, and so that's what we have. Brief history of the Holland Land Company, I won't get into. Not an expert at it, but I do give talks on it to service groups, senior citizens, a couple times a year. So if you want to hear anything about it, look under senior citizen notices in the newspaper. I may be in there.
Thank you very much.
Thank you so much for your kind attention.